But note, it is a maxim in law that witnesses cannot testify a negative, but can only prove an affirmative. If one of the witnesses named in the deed be one of the panel, he shall be put out of the panel. If all the witnesses be dead, and no man can keep his witnesses alive, for time weareth out all men, then continual and quiet possession is a violent presumption of right, and stands for a proof, i.e. till rebutted. Note, it hath been resolved that a wife cannot be produced either for or against her husband, quia sunt dua anime in carne una, and it might be a cause of implacable discord and dissension between them, and a means of great inconvenience. But now let us return to that from which, by way of digression, upon this occasion we are fallen. I have termed the said parts of the deed the formal or orderly parts, but they are not of the essence of a deed of fiefment. For if such a deed be without premises, habendum, tenendum, redendum, clause of warranty, clause of insidious res testimonium, the date, or the clause of his testibus, yet the deed is good. For if a man by deed gives lands to another and to his heirs without saying more, this is good. If he put his seal to the deed, deliver it, and make livery accordingly. So it is if A give lands to have and to hold E and his heirs, this is good, albeit the fee is not named in the premises. But no well-advised man should trust to such deeds which the law by construction only makes good, et res magnus valeat. But when form and substance concur, then is the deed fair and absolutely good. To him and to his heirs. Heirs, in the legal understanding of the common law, implieth that he is ex justis nuptius procreatus, for heirs legitimus es quem nuptia demonstrant, and is he to whom lands, tenements, or herediments by the act of God and right of blood do descend of some estate of inheritance. A monster which has not the shape of mankind cannot be heir or inherit any land, albeit it be brought forth within marriage, but although he has deformity in any part of his body, yet if he has human shape, he may be heir. Neither can a bastard be heir, as hath been before said. Every heir is either a male or female or an hermaphrodite, that is both male and female, and an hermaphrodite, which is also called androgynous, shall be heir, either male or female, according to that kind of sex which prevails. Hermaphrodita tum masculo quam feminae comparator secundum prevalescentium sexus incalescentis, and accordingly it ought to be baptized. See more of this matter in section 35. A man seized of lands in fee hath issue an alien that is born out of the king's allegiance. He cannot be heir, propter defectum subjectinus, albeit he be born within lawful marriage. If made denizen by the king's letters patent, yet cannot be inherent to his father or any other. But otherwise it is, if he be naturalized by act of parliament, for then he is not accounted in law an alien but a subject. But after one be made denizen, the issue that he has afterwards shall be heir to him, but no issue that he had before. If an alien comes into England and has issue 2 sons, these 2 sons are indigene subjects born, because they are born within the realm. And yet if one of them purchase lands in fee and dies without issue, his brother shall not be his heir, for there was never any inheritable blood between the father and them. And where the sons by no possibility can be heir to the father, one of them shall not be heir to the other. See more of this matter in section 198. In the 25th reign of George II, chapter 40. If a man be attainted of treason or felony, although he be born within wedlock, he can be heir to no man, nor any man heir to him, to delictum, for that by his attainder his blood is corrupted. And this corruption of blood is so high that it cannot be absolutely solved and restored but by act of parliament. For albeit the person attainted obtain his charter of pardon, yet that does not make any to be heir whose blood was corrupted at the time of the attainder. either downward or upward. As if a man has issue a son before his attainder, and obtains his pardon, and after the pardon has issued another son, at the time of the attainder of the blood of the eldest was corrupted, and therefore he cannot be heir. But if he die, living his father, the younger son shall be heir, for he was not in S at the time of the attainder, but the pardon restored the blood as to all issues begotten afterwards. But in that case, if the eldest son had survived the father, the younger son cannot be heir, because he has an elder brother who by possibility might have inherited. But if the elder brother had been an alien, the younger son should be heir, for that the alien never had any inheritable blood in him. See more plentifully in this matter in section 746-747. If a man has issued 2 sons, and after is attainted of treason or felony, and one of the sons purchase land and dies without issue, the other brother shall be his heir, for the attainder of the father corrupts the lineal blood only, and not the collateral blood between the brethren, which was vested in them before the attainder, and each of them by possibility might have been heir to the father. But otherwise it is in the case of the alienee, as have been said. But some have holden that if a man after he be attainted of treason or felony have issued 2 sons, that the one of them cannot be heir to the other, because they could not be heir to the father, for that they had no inheritable blood in them. One that is born deaf and dumb may be heir to another, albeit it was otherwise holden in ancient time. And so if born deaf, dumb, and blind, for in hoc casu vitio perictor naturali, but contract they cannot, idiots, lepers, madmen, outlaws in debt, trespassers, or the like, persons excommunicated, men attainted in a procurum or convicted of hearsay, may be heirs. If a man has a wife and dies, within a very short time after the wife marries again, and within 9 months have a child, so as it may be the child of the one or the other, some have said that in this case the child may choose his father. Cua in hoc casa fibratio non protest probari, for avoiding of which question and other inconveniences, this was the law before the conquest. Man by common law cannot be heir to goods or chattels, for heirs differ ab hereditate. If a man buy divers fish as carp, bream, tench, etc., and put them in his pond, and dies, in this case the heir shall have them, and not the executors. They shall go with the inheritance, because they were at liberty, and could not be gotten without industry as by nets and other engines. Otherwise it is, if they were in a trunk or the like, likewise deer in a park, ponies in a warren, and doves in a dove house, young and old, shall go to the heir. But of ancient time the heir was permitted to have an action of debt upon a bond made to his ancestor and his heirs, but the law is not so held at this day. Vide section 12.